The use of the mandatory term therefore means that all that they do is to establish a prima facie case. And once he has done that, the burden shifts to the IBC to prove that they conducted elections that comply with the Constitution. That is the burden that I would like this court to note. The second thing to note there is that those impose obligations on the IBC which ought to be observed. And it's incumbent upon this court to enforce those obligations if they think the IBC is not observing its obligations. And on that, again, I refer to the Waiko and another at pages 97, at page 97 and 90. To revise that decision, and you are interpreting the Constitution in terms of Article 259, you must bear in mind that 259 requires this court to interpret the Constitution in a manner that develops the law. In terms of that it's you will be able for that elections easy for us. Who's and I want that, from that point of view, that thank you. So I will be urging, therefore, that this case is about the protection of the sovereignty of the people of Kenya. If we can see there is a threat to usurp that sovereignty, we must protect it. And if you look at Article 249, you need to know that the Electoral Commission has a responsibility to protect the sovereignty of the people. One of the objects of commissions is to protect the sovereignty of the people. And you look through elections 2007, 2013, up to now, there seems to be a pattern where that state organ has failed in that responsibility. And having failed in that responsibility, I want to urge that this case before you is like the Kenyan people have come to you to defend the Constitution and protect their sovereignty. And if you look at Article 3 of the Constitution, it makes it very clear that every person has an obligation to defend the Constitution. The people of Kenya have come to you to assist them to defend the Constitution through lawful means and to protect their sovereignty. And so I want to emphasize that when you are making your decision, let that bear on your mind, that it is as serious as either choosing between to stand with the people trying to protect their sovereignty or to stand with those who are usurping the sovereignty of the people. Thank you very much.
Thank you. Thank you. Dr. Kangu.
Yeah. My Lord, we just have... Sorry. My Lord, we just have two things to do. There's a matter of evidence that through my learned friend, Mr. Otinda Molo, is going to lay a basis for it. It's something that may take less than 10 minutes. And I'll take 10 minutes thereafter to wrap up our case.
Go ahead.
A bit of reorganization, Anthony Oloch.
Your Lordship, Chief Justice, my ladies, I have just one small component of the evidence that was presented by my learned senior, Mr. Otiende Amolo. But before they play that video, I just wanted to draw Your Lordship's attention and your ladies to two paragraphs of two affidavits of the applicant, and then juxtapose it against the video evidence that is going to be played. The first affidavit is the affidavit of Volume 2 of the first respondent, and it's the affidavit of James Muhati. And it goes into part of the evidence in terms of what kind of security features and compliance issues the first respondent put in place in order to ensure that there was a proper ICT infrastructure for purposes of the elections. It is important that we set out from the very onset that the IEBC set out a system which it has highlighted under paragraphs 34 of the affidavit of Muhati. And at paragraph 34, and I will not read it, your lordships will find time to read it, it is a mirror of the video that we are about to present of the late Muhati, of what ought to have happened, the late Musando, thank you very much, if the electoral system, and especially the results transmission system, had worked in the manner contemplated. And so I would like your lordship to take into account paragraphs 34, paragraphs 35, and paragraphs 36 up to 39 of these affidavit. We also want to submit to your lordships that in terms of ICT security, we want to flag out paragraph 39 of the affidavit of Ezra Chiloba. That is the affidavit that was dated, sorry, my lords. It's dated the 24th of August, 2017. Looking at what Muhati says and the video that will be presented of Musando, the IBC set a system where it would have been impossible for third parties to have access or super access into that system. We set out in our evidence that in relation to a case that took place in Mandera, basically materials foreign to what is prescribed as Form 34 found itself into the web portal of IEBC. And in the affidavit of Ezra Chiloba, he admits that this was foreign material and not prescribed Form 34s, and says that he was able to get into the system and expunge this material. So then that puts into question the idea of the integrity of the infrastructure that was put in place by the IEBC. So those are the 2 points that I want to make, and there are 2 very short videos of the late Musando that we want to play. There are transcriptions of the same. We have also annexed the certificates to our applications. So please.
Mr. Olwatch, as regards this matter that you are now showing,
yes,
it is something that qualifies as dying declarations as evidence.
Pardon, my lord?
Does it qualify as dying declarations?
Not quite.
Not quite. Not quite. I'm going to make a statement at the end that will clarify that point. So once we play it, I will make a point in relation to that. My lords, I'm reminded here by my senior that a dying declaration is made by somebody who says it in expectation of death. We don't think that the late Musando expected his unfortunate death, so it would not be a dying declaration.
I think in that case, we'll say something about the evidentiary strength. You'll have to say something about that.
Yeah. Okay, very well.
Summarize it now. If it doesn't come, yes, you will pass the court.
And how we want to operate in relation has taken into consideration very many aspects of possible failures. One of them is the total failure of the device. The other one is total failure of identification of the voters of election day, especially the biometric. But we have put measures in place to mitigate that. One of the measures that we have put in case of total failure of the device, we have standby devices. We have 40,000, less than 40,800 polling stations. We have 45,000 devices, and therefore we have cut up for additional devices per award. Each ward will be having at least 4 devices on standby, fully configured, and ready to be deployed in case of a full failure of a device. Besides that, we have also put in place the technical capacity of officers trained to be able to troubleshoot some of these devices in case of failure. Because you see, a failure can sometimes get resolved by some technical knowledge, and that we have put in place. We have 580 ICT assistants who will be well trained to support the technology on election day, and each constituency will have 2 technical people. We also have technical support at all